Good afternoon. Welcome to our Employment Handbook webinar. This is part one of 3 webinar presentations we will do in 2019. My name is Carl Habekost. I'm an attorney with Bugbee & Conkle, working in the Labor and Employment section. We have Elizabeth Bolduc today. Elizabeth?
Hi, everyone. I'm also an attorney here at Bugbee & Conkle, working in the Labor and Employment section.
Carrie Ramirez is our operations manager, and she put all this together, so we would like to thank Carrie. We'd also like to thank you for attending this webinar. We will make good use of your time so that you can pick up some useful information and tidbits. And I think, there any other preliminary information?
I think just make sure everyone puts their settings on mute. And if you have any questions, go ahead and ask them. We'll answer them as they come up if they're relevant. And if not, we'll just wait to the end to answer all the other questions.
All right. Well, let's get rolling. What we thought we would do is just do a quick review. In December, we did a webinar overview on employment handbooks and why they are important. They are a communication tool. It is a company's first opportunity to communicate to prospective employees about your culture, about what the company believes is important, about how glad the company is that the employee is working for them, and how valuable they are. It also is an excellent opportunity to reinforce important information to your current employees. So it's an excellent communication tool. It also provides job information, talks about hours of work, maybe the actual work week, when you get paid, work rules, disciplinary procedures, and finally, in today's world, an employment handbook provides legal protection to employers, assuming that the handbook complies with all the rules and regulations that change constantly, especially in the various administrative agencies. Today, we're really going to focus on one specific element of a handbook, and that is workplace safety. Our next webinar, I believe, Elizabeth, we're going to talk about leaves and benefits and that information? Okay. So today we're going to focus on safety. Safety is important. You want to let your people know that safety is important. We always recommend, say it. Put it in the handbook. Have some sort of statement that you value your employees. Most employees feel as if they're just a profit center. All they are therefore is to make the company money, and nobody cares about them. And safety is one area that you can let your employees know that they are valuable and safety is a priority. Elizabeth?
Yeah, so this is a great thing since we're talking about outset of what a handbook looks like and especially what you can do in regards to safety. A handbook will set your culture, or it will start to begin to do so. And so if you have a culture that focuses on safety and conveys to employees that safety is a priority, then you're going to set the stage for employees to start taking safer precautions, whether it's just walking through the hallways, holding the handrails when they're going down steps, and other things that they do periodically through their employment to take safer steps. And they do that because they know that it's important to the culture. So that's, something that I think is really, really important here. And if you take only one thing here away today, Carl might disagree with me, it is that by putting and focusing on safety in your handbook, you're beginning to set a safety culture, and that goes a long way.
Oh, I totally agree. In fact, we've done a couple of webinars on how to develop a safety culture and why that is important. And part of that is to emphasize to the employees that they should report injuries promptly. It gets to be a difficult situation when somebody alleges an injury 3 weeks later. maybe a safety hazard has been there for 3 weeks and you didn't know anything about it as the HR manager or safety manager. So from the perspective of taking care of your employees, you need to emphasize in the handbook, promptly report any injuries, or as important, report the fact that, wow, we almost got hurt, we almost had an accident, and here's why. And then that way, people can fix it.
Right.
Okay. Now, this is something Elizabeth probably runs into quite a bit when you're dealing with employment cases that flow out of workplace safety issues.
Yeah, so surprisingly enough, or maybe not, a lot of litigation comes out of accidents that happen in the work, whether it's people tripping or their hand getting stuck in something. And then that, kind of weaves its way into other employment litigation. And so one thing you can do in your handbook is set, what do you do if an accident happens? What is an investigation going to look like? And so these are kind of the key elements here of things that you should identify and address in a handbook. So first, you're going to want to say that we promptly, as Carl was saying, investigate these things, and we, require employees to promptly report when there's been an accident. And based on your report, we will take this seriously, and we're going to investigate it. And then from the investigation, we're going to identify the responsible parties. And so who are the right people to talk to? We're going to talk to the supervisor. We're going to talk to the witnesses. Maybe the safety director is going to get involved. And so they're aware of kind of how this is going to look. And then you're going to gather statements to support whether or not maybe something happened. And it's funny, the more and more you start talking to people, the more and more stories you might hear. And that will put just a couple stories in context so you can come out with the correct solution or the correct, probably the possible scenario rather than just one side of the story. And then from that, you're going to get an idea of the complete accident, and that way it will help you put it into our report.
Before we move on, do you have any sort of recommended language that employers may want to put in there about confidentiality when you're doing the accident investigation?
Yeah, so when you're doing the accident investigation, I think it is, a correct statement to say we will keep things as confidential as possible. In investigations, it's almost and always actually impossible to completely keep things confidential because there's a lot of moving parts, and maybe you'll have to, show the alleged, person who was injured the witness statement saying that they weren't, or that this really happened. And so to get the correct statement, you really do sometimes have to break that confidentiality. But with that being said, you should ensure your employees that, you're going to keep it as confidential as possible. So you're not going to tell people who are not pertinent to the investigation.
Okay. Thank you.
Good question.
Put you on the spot.
Yeah, that's okay.
Well, OSHA has had, all over the last, say, 3 or 4 years, a temporary worker initiative. And the reason for that is that many times what we call host employers, those are the employers who hire staffing company employees, they tend to believe that they don't really have any responsibility. That the temps come in, they do their job, they don't get any training, sometimes they don't even get any personal protective equipment, and they leave. Host employers believe they can fire somebody, a temp employee, for no reason at all, even contrary to law, and they think they don't have any liability. But for purposes today, we're talking about safety, and OSHA is emphasizing that this is a sort of joint employment relationship. Both the staffing agency and the host employer have responsibility for training temporary employees and making sure that they're safe, just like all employees. And an example of this is actually an example that comes out of OSHA material. Personal protective equipment. The host employer usually has the primary responsibility for selecting, providing, and ensuring the use of adequate personal protective equipment. And why is that? Because the host employer knows what's going on. They know how the machine operates. They know whether there are going to be wood chips flying around. They know whether there will be dust floating and can get into the eye. So that's why the host employer has the primary responsibility to determine what personal protective equipment is appropriate and when it needs to be used. However, the staffing agency is not off the hook. The staffing agency has to have some understanding of the hazards that their employees are exposed to at the places of employment that they send their employees. So the OSHA actually has taken the position that both employers are responsible, and OSHA will issue citations many times against both the host employer and the staffing company. So we want you to be aware of that so that you train your staffing employees. Elizabeth?
Yeah, and if you are in any type of staffing agency, that's why it's important when you give employees a handbook, it's what the rules are for your company, but then also those policies should reflect that once that employee is placed with their host company, that they should inquire about what the safety policies and procedures are there. So for temporary staffing agencies, you should not only have policies that reflect what you require of your own employees, but you should also have language in there that delegates that, the safety policy of the host employer. And that way you kind of have a double whammy of saying, okay, this is our safety culture, but also safety is so important. You also have to realize where you're working, safety culture is important.
Right. In fact, it's a little random, but those who know me are not surprised that I issue random comments from time to time. But the staffing employees should comply with all aspects of the host employee handbook, and that includes disciplinary procedure, whether they're late for work, whether they violate work rules, safety rules, and the disciplinary policy of the host employer many times controls in that situation. A lot of this between the host employer and the staffing company can be handled by a contract, a service contract between the two employers. But we just wanted you to be aware of that. It's a big deal for OSHA. Next slide.
All right.
Now, this is Elizabeth.
So I think a lot of times we see big red flags when we get handbooks to revise, and when we pull up the safety rule, it seems like every past accident has been listed in the handbook. And so I think that's one of the number one errors. You don't need to list every single safety rule you can possibly ever think of to keep every employee as safe as possible. I mean, that seems like a law school torts exam to me, where a professor is typing up every single accident possible. So stay away from just listing every safety rule, but more than anything, provide guidance of the types of things that you care about, which we're going to get into, and how they're going to follow those policies. And then, indicate that, the policies that are in the handbook are just kind of a floor, but they're going to get annual training on the things that really matter. And when you're in those trainings, have employees sign in and, reference the material. So later you can show that the employee who attended this training on X date saw these materials, and you want to make sure those are all saved in a safety training file or however makes sense to your organization. But certainly there shouldn't just be one safety policy in the handbook that lists everything and then you never talk about safety again.
Right. So basically you have some basic safety rules in your handbook, but the majority of the safety rules will be in a different place. Yeah,
based on probably training.
Right.
Yeah.
Employee involvement in injury reporting. The important aspect of the handbook is to advise the employees how to report an injury. And it's got to be a reasonable process. In other words, and believe it or not, we have seen this. The employee has to call within 1 hour of the accident their immediate supervisor. Then they have to call the safety manager. And then finally, they have to report into the human resource department that they had an injury. And if they don't follow those 3 different reporting rules, they can be subject to discipline. That's really not a reasonable process. The procedure should encourage basically prompt and accurate reporting, because the procedure I just outlined really deters reporting. Do you agree?
Yeah, so I think this is true for all employment policies when you're talking about reporting procedures, but you'll want to make sure that there's multiple methods that an employee can report an accident or a problem. So maybe it's human resources, maybe it's their direct supervisor. But at the end of the day, if they go to someone in leadership and say, hey, I just really injured my hand and I need help, all of your supervisors should be tasked with knowing how to help that person, at least get the right paperwork or let their supervisor know. So kind of help being a liaison. But yeah, simply having one person or follow an exact chain of command to report is always going to deter people from reporting. And then that, regulations have come out to say, and guidance, that those type of policies really are not effective and they're not given much weight when you're in litigation.
So basically then, Elizabeth, would you say that the handbook should succinctly state the employee must report an injury as soon as possible or as soon as practicable to their direct supervisor or the safety manager or something like that?
Yeah.
Just a real clear,
give them a couple options or ways, because what if their supervisor is on break?
Right.
Who are they going to go? Are they going to wait for an hour while their supervisor is on lunch? And then what if they can only report within an hour and now they've exhausted their time? So give them, some leeway of saying, as soon as you are aware of this injury or it occurred, and then give a couple methods. And that's really important, because when in litigation, when we look at those policies, it might be a defense. And if you have a really weak policy, then your defense is also weak.
Right.
And so this is something that I think is crucial, because I deal with this a lot in our office, is anti-discrimination policies. So this is, kind of many people are aware of whistleblower protection. So anytime someone, reports to OSHA that an accident happened, or that they complain about something being unsafe in the workplace, or they even report a workplace injury, and maybe file a workers' compensation claim, that they are protected by this anti-discrimination policy, which means that you will not retaliate in the workplace because they participated in an investigation, or because they filed a workers' compensation claim, or because, they contacted OSHA or participated in the OSHA investigation when OSHA came out and talked to employees. And you're going to want to not only have this in your handbook, but you're going to want them to understand this. And so if you do an anti-discrimination training, which I hope everyone does, touch on this and then have those employees sign off that they're aware of this.
Right. They want to be free to report unsafe work environment even. For example, they don't have safety cones to put around where they're trimming bushes, put it on the driveway or whatnot.
Yeah.
Yeah.
And so that's going to also tie into the fact that, bad policies are policies that show or make these hurdles so employees will not report. And so when you have an anti-discrimination policy to back up your original policy, it's more evidence that you are not preventing employees from filing or complaining or reporting.
So this slide really is just sort of a ting-a-ling, be aware that OSHA takes a skewed look at policies that clearly indicate employees have to report injuries within 1 hour or within 4 hours of the accident, or they're subject to discipline.
Right.
Now, if somebody develops carpal tunnel syndrome, which is a cumulative trauma disorder in the wrist, and tissue begins to swell over a period of time when it's stressed over and over again, the employee doesn't really know exactly when the accident happened. And we've seen cases where employers terminated the employee for not reporting an injury such as carpal tunnel syndrome immediately when, maybe the doctor gave a dated diagnosis of January 10th, and the employee just sort of figures it out in today's March 20th, and the employers would discipline people for that. Well, that's ridiculous. And OSHA actually talked about this in the recording rule in 2016, and we've done webinars on that. So if you have any questions on that, feel free to contact us. A hot topic, folks, workplace violence. And Elizabeth can talk about this some, but the point of this is that it is a very hot topic, and you have to have a workplace violence policy.
Yeah, I think a lot of times those who are just new to the safety industry do not really realize, that workplace violence is actually one of the biggest threats to your employees. So I think a lot of times employers are really concentrated on other things, but statistics actually show that workplace violence makes up roughly about 2 million crimes a year, which is crazy. And so this comes from a couple different ways. It's sometimes employee-on-employee crime. So, Carl has made me mad today, and I'm going to beat him up.
More than one.
Or, and because I'm a woman, I think this hits home for me. A lot of times there is, and it doesn't happen to just women, but there's domestic violence that occurs. And when employers completely, disengage from that or ignore that, they're really forgetting a big threat. And that is when, outside people, specifically, partners or family members come in and there's crimes against employees that way. And certainly there's customers and clients and things like that make up the statistics too.
Well, this next slide really emphasizes what you just talked about, Elizabeth. The graph to the far left shows that by far the leading cause of homicide for females or women is a relative or domestic partner, 43%. That's just as significant. We've had clients that call us and ask how to handle that situation. And the first thing we say is, do you have any sort of policy in your handbook that discusses that? For example, a couple might be going through a divorce, and the statistics show this out. It's not always true, but it's generally a man who's upset, and he's made threats against his spouse or soon-to-be ex-spouse, and he's sitting in the parking lot. And how does an employer handle that? So, to the best of your ability, you should try to talk about it in your handbook as briefly as possible.
Yeah, and sometimes maybe it isn't a huge policy that addresses every issue, but rather it's lunch and learns, right? So have something where you provide some lunch to your employees, get them there, get them interested in this topic, and say, if you have a personal problem going on in your life, such as maybe domestic violence, come talk to us. We want to protect you. We want to help you. We're a partner with you. You're not just here to be our worker bee, but we care about your longevity and your well-being. And so we're going to protect you the best we can, whether it's a policy that, people have to have a badge or be escorted with someone with a badge, or, we have a secured parking lot. But, I think when you encourage employees to come talk to you about what's going on so you can help keep them safe, you not only have this great culture, but you also, you know, you let them know that they're cared about.
So basically, it's sort of a educational theory that we kind of circle around from time to time and touch base on what we've already talked about. Those of you who have been to our seminars and through these webinars know that we do this. Well, we basically just talked about different types of workplace violence. We want to touch base on it again so that you can deal with it in your particular industry. Every industry has their own issue. If you're operating a convenience store, you're going to be more prone to having a violence in the form of a criminal situation where somebody comes in with a gun and tries to rob your store, and you have an employee there by themselves in the store at 2 o'clock in the morning. That's probably not a good idea. So companies should have at least 2 people working, have safety glass, that sort of thing. If you're in the healthcare industry, you're going to deal more with customer-client type of violence. Psychiatric facilities and long-term care facilities have significant risk or violence from their patients. Surprisingly, worker-on-worker violence is not as common as one would think. Those kinds of situations get a lot of press, where a disgruntled employee comes in and starts blowing away his coworkers. But statistically, those incidents are low on the totem pole, but they're significant. I mean, you know, the damage is very significant. And we've already talked about personal relationships, but we just wanted to review that with you. And this slide sort of does the same thing in a different format. Depends on what you like. You like the pictures?
All right. Yeah. So we're going to kind of, you know, I think we've talked about some of this throughout our presentation, but again, you know, when you're developing workplace bullying and violence policies, you're going to want to say and convey that the corporation or the business has a strong commitment and obligation to provide a safe work environment for all of its employees. And that's important because, you know, if employees feel that you're committed to keeping them safe, they're more likely to engage in safety culture and safety programs. And, you know, I think this is one that I've been getting a lot of questions about lately, is what is workplace violence and bullying? So I think a lot of times I have employers, and because I do a lot of harassment here, I have a lot of employers say, well, you know.
You harass me a lot.
I have a defense for that, I swear. But yeah, so they come to me and say, well, you know, this is not the definition of harassment under, you know, Title VII. So we're safe here. And in a practical and legal matter, maybe that's true, but there's certainly really some things that could come from bullying, and that is workplace crime, and that's when you can become liable. And so those are behaviors you're going to want to stop, and so that's, you know, whatever your industry is. I know sometimes in the nursing profession there is more females, so there's a lot of more catty behavior, and then that's kind of the bullying behavior you would address. But maybe if it's a factory floor and you have a lot of, you know, locker room or, you know, kind of man talk, or you would want to address it there, or I think specifically there's been some cases in Toledo about hazing in the workplace. Right. And so certainly there you're going to want to say absolutely not. There's no tolerance for this type of behaviors, and kind of address it there. And then again, echoing whatever we said earlier, but follow it up with training. And then saying that this policy applies to everyone. So, you know, there can be supervisor on employee violence and vice versa. It applies to vendors, contractors, customers. So not that it only applies to that employee. And then we already talked about the last one, so I think we're good.
Well, distracted driving. We were actually just talking about this 5 minutes before the webinar kicked off. Carrie was telling us that WTOL did a little presentation, I guess, a few minutes on accidents that are occurring on Interstate 75 right around Toledo. The accident rate is up significantly. Now, they are doing construction there. But, Carrie, what were you saying, that they think it's because of distracted driving as well, correct? Carrie's shaking her head yes. She does not like the fact I just put her on the spot. But distracted driving is a very big issue. Mm-hmm. It really, really is. And well, I'll give you an example. Ohio has had a distracted driving law in Ohio Revised Code since 2012. For those of you who are super interested in it, it's Revised Code 4511.201. That law, as it was issued in 2012 or enacted in 2012, spoke directly to texting. It became effective in January of 2019 as a more broad approach to distracted driving. So it's not just texting, it's any sort of distraction, anything that takes an individual's mind off of driving. The new law really allows the police to give a citation above and beyond the moving violation. They can add another citation that costs another $150 for distracted driving. And they don't have to necessarily prove that you were texting, but you could be changing the radio station, you could be eating, fixing your hair, whatever, you're just not paying attention. So all of these are distracted driving examples. There are three types. There are visual, manual, and cognitive. The reason texting is such an issue is that it involves all three types of distractions. Elizabeth, do you want to add anything on this, Elizabeth? No. So you have to have a distracted driving policy.
We'll get to the reason why. I know we're leaving it kind of as a cliffhanger, but we'll get to it. Yeah.
You can't leave early.
Yeah, that's how we do it here.
Yeah.
So what does a distracted driving policy look like? And so these are the things that Carl kind of just went through. Define what it is. So, eating and the things we just talked about, talking on the phone, texting, having even, conversations, workplace conversations in the car that you're looking at documents. I mean, I can admit that I've been in a car before and I've had a conference call and admittedly I've taken notes. Like maybe I wasn't driving necessarily, but there are people out in the car and it is really a distracted driving. And there's a couple of reasons why, later on that matters to you as an employer. But also, so define that and then, let them know that this policy has been implemented to make sure that they're safe. You don't want them to get hurt at work. If they're doing things work-related, it's going to go into workers' compensation and possibly be a claim. But also, what if they are in a car accident? Hopefully they don't die, but they could be, really injured and then they're off of work for a really long time. And so it's just better to have a distracted driving policy.
Yes, we keep bringing this agency up, but OSHA has publicly called on employers by way of memorandums and also on their website to develop policies that prohibit texting while driving. They're using the general duty clause at Section 5A to say that employers have a general duty to provide a workplace free of recognized hazards, and clearly a recognized hazard is texting while driving and otherwise being distracted. We've already covered the Ohio law about distracted driving, and technology really has changed the way people work anymore. So we're working more and more remotely. That involves technology. We do a lot of driving in our office. We drive all over the place. It's difficult to do your work while you're driving all the time, so the tendency is for us to want to
be efficient.
Be efficient, work on this, work while we're driving, and you just can't do that.
Yeah. Definitely not. And the reason why, I mean, this really matters is because of liability. And so like I've mentioned earlier, there's workers' compensation at play here. If someone is working and they get hurt, then the claim is compensable. But also there could be maybe an intentional tort. You know, my employer requires me to work these many hours a day or, you know, be on this conference call, and they knew I was driving or they knew I was on my way to a meeting, but they still made me take this call. I mean, that can show that it's deliberate intent, knowing that they're engaging in distracted driving. And so I did use a couple of legal phrases, so I apologize for anyone's ears who are currently bleeding. But yeah, there's a lot of reasons this matter. And then I think I said earlier, you care about your employees, right?
Yeah, so that's a good point. We'll just reinforce that. The employer can have liability above and beyond the workers' compensation issue for damages that either happen to their employee or that the employee caused because they were driving and doing business at the same time, and God forbid it would be the employee supervisor who knew their schedule, knew they were driving, and insisted that they engage in work while driving.
Yep.
So distracted driving policy should ban handheld and hands-free cell phone use while operating a vehicle while working.
And, you know, I've worked in-house in a company that even extended this policy to the parking lot. So not at a stop sign, not at a stoplight, not on the road at all, not in the parking lot. You don't want someone texting and driving that is not paying attention in the parking lot and hit another employee. I mean, there's just a lot of things going on there. So I think it's a common, you know, well, if they're just over their Bluetooth speaker, it's fine. And really, it should just be a complete ban.
Exactly. And I think there are a lot of sample policies out there. And if you have any issues with that, please contact us. Well, we have covered what we consider to be sort of the basic safety issues involving handbooks. Now we're going to get to the good stuff, drugs and alcohol. Marijuana, it's hard for me to even begin to grasp how much press time marijuana gets, but it's crazy. Marijuana tops the list as the most detected substance on all drug tests. Between 2015 and 2017, the transportation industry alone experienced over a 21% increase in positive drug testing for marijuana. This slide has a lot of different data as far as drug testing. It's not just marijuana, but the reason marijuana is becoming important in our discussion today is that several states have legalized marijuana for medical purposes and also recreational purposes. How do employers handle this? It's especially difficult because it's like a patchwork of laws. California's laws are different than Ohio.
Yeah, and that's why I think if you were at our kickoff series, we mentioned that each handbook should be distinct to that plant or you know, that location. So Ohio handbook should look a little bit different than maybe Michigan, because in Michigan there is recreational and medical legal marijuana, but here in Ohio, it's only medical, and then, you know, in some states there's absolutely none. So there should be some policies that fluctuate a little bit. And like Carl said, this is one thing that is completely, you know, controlled by federalism, and each state controls it. So everything should look a little bit different.
Yep, marijuana is popular. I mean, the cultural view on marijuana is changing as the graph to the left shows. And frankly, at some point, Congress is going to weigh in and just take marijuana off the list as a Schedule I drug. Currently, it's right up there with LSD and all these other drugs, heroin, yeah. Any other? It breaks down by age. as far as who thinks marijuana is okay and who doesn't. So let's talk about Ohio. Most of our clients are in Ohio, although they do have places in different states. But we're going to talk about Ohio at this point simply because Ohio has a relatively new medical marijuana law. It is very, very restrictive.
Which makes employer management attorneys very happy.
Yeah, it's limited to certain qualifying medical conditions. And here they are. And like I said before, we have done webinars on medical marijuana. So we're just kind of touching base on this. We will expect there'll be other conditions added, but at this point in time, a patient has to have one of these conditions, been diagnosed with one of these conditions, and then have medical marijuana recommended as a treatment. Which ones do you think probably has the most diagnosis, the condition? It's probably the one that has the least objective criteria. Well, golly, that's pain. Pain is the least objective criteria for a diagnosis, and that's the one that is diagnosed most often. So why do we care? Why are we talking about this? Because employers are concerned how this affects their drug policies and their workplace. We have clients who have made a purposeful decision to take marijuana out of the screening process. They just don't want to know if somebody's using marijuana or not. We'll talk about that in a second. But these are the concerns that employers have expressed, at least to us anyway, as to how marijuana will impact their policies. We can tell you that in Ohio, the law has been written in such a way that really you don't have to change a whole lot in your policy.
Yeah, I think because, this has been a topic that has been taboo for such a long time that now that things are moving, there's been kind of a knee-jerk reaction, and it's been a lot of chaos, maybe the headlines, oh no, we have so much work to do, everything's changing. And luckily to say, in Ohio, employers really can keep the policies that they have in place. Nothing should change from those. However, employers might want to take a conscious decision-making to determine whether or not they want to make modifications. So it's more a business decision at this point, but certainly that's kind of what we're addressing today.
Right. So your alcohol and drug policies can remain the same for the most part. Depends on what you want to do. The question is going to come up. Why do you have an alcohol and drug testing policy? Do you do it pre-employment, post-accident, maybe reasonable suspicion? What are you going to do if somebody tells you, I have a medical marijuana recommendation from a doctor, and I do it in the evening as it's recommended to me because it helps me sleep. I have a very bad back. And sure, I'm going to test positive for THC in my system, but I don't do it during the day. I don't do it in the workplace, and I'm not stoned at work. Our testing process, at least the scientific status of our testing for marijuana, does not necessarily show impairment. It shows the presence of THC per nanograms in your system. And we can have doctors say that if you have 100 nanograms of THC per milliliter of urine in your system, that probably means you're intoxicated. But unlike alcohol, which is pretty clear, we have a lot of data on that. If you test above a 0.08, let's say, for alcohol, they have enough scientific data to establish that you're impaired and you shouldn't be driving. You shouldn't be operating a press at work. You shouldn't be driving a tow truck. We don't really have that for marijuana. So that's some considerations that employers need to take into account when they're developing their drug and alcohol policies. And I never answered the question. Here's the question again. What do you do if somebody comes in and says, I have a bad back and I do marijuana in the evening as recommended by my doctor, and sure, I'm going to test positive. What do you do? What if they say, hey, I'm disabled and I need you to accommodate my marijuana use?
Yeah, so in Ohio, employers do not have an obligation to allow employees to use marijuana as a reasonable accommodation. And that's, they do not have to, meaning you can. But if you decide to make that business decision, you're going to want to make sure that you're consistent and that everyone who has a card or shows proof that it's been prescribed for them is treated in the same manner. And so maybe you do allow them to you know, test positive on a drug test, but then if they come to work and they appear intoxicated, you give them a reasonable suspicion, and if they test positive then, maybe you take certain procedures and precautions, and so there's certain ways you can kind of navigate the waters. But to answer Carl's question is, right now, currently in Ohio, employers do not have to accommodate an employee's drug use.
Great. And one question. How many times do you hear our clients ask this question, Elizabeth? What do we do? Joe Smith got injured and he reported it, but he said, I don't really need any medical treatment. I'm not going to go to the doctor right now. And I'm just going to keep working. It's no big deal. I just wanted to let you know that I bumped my toe and it kind of hurt. And 2 days later, they go, you know what? My toe's all swollen and I need to go get medical treatment. And then they say, okay, now we're going to do a post-accident drug test. But it's 48 hours after the accident.
Yeah, that's why it's really important to, I think when we talked about what a policy looks like, it was, you know, that investigation process. And so part of that is maybe having them go to a doctor and immediately be tested and make sure that, you know, there is not a drug to blame here for the accident, or maybe, you know, part of it. And so that's why it's really important to address this in your policies when you go back to the slides for those who take the handouts. Look at what that looks like. But also, I think, you know, in your policy, if someone leaves the scene from an accident or, you know, doesn't take a drug screening, so, you know, says, okay, yeah, I'll go get my drug screening or after an accident, and they don't, then your policy says how you're going to deal with that. And if you're going to deal with that by terminating an employee, then at all times you need to follow your policy, and so that you are consistent in how you are handling post-accident injuries and drug tests.
Absolutely. A real nice sentence that we recommend employers have in their drug testing policy. And by the way, the language in a drug testing policy is important. So it's kind of tough to pull one sentence out. But here's a good sentence. Employees who leave the scene of an accident without justifiable explanation prior to submission to a drug or alcohol test will be considered to have refused to submit to the test and will automatically be subject to discharge. That follows prior language that says if you refuse to take a post-accident drug and alcohol test, you're going to be terminated immediately, and that's going to be considered a positive test. Because we run into this all the time, not all the time, but I mean regularly enough it doesn't surprise us that people just leave the scene of an accident, drive away in their car, the employer doesn't know anything about them for a week or two, and the employer was deprived of the opportunity to do a drug and alcohol test. And why is that important? It's also important for safety. It may be that there's nothing wrong with this machine, or there was nothing wrong with the tow truck, or there's nothing wrong with the procedure to do the job. may very well be that this person was impaired, but you don't have the opportunity to investigate the root cause of the accident without performing a drug test and an alcohol test. That very well might be a cause. So that's why it's important for employers to have a good drug and alcohol policy and to enforce it and be consistent. And also, I don't know that we talked about it, the confidentiality of those drug tests and alcohol test results must be strictly enforced.
Yeah, and how you keep the results, make sure that they're in a separate file.
Separate file, yeah.
Yeah, and so you're going to want to keep those in a locked drawer where people will not have access to medical information.
Exactly. There are different ways to test for drug and alcohol. We're just throwing this slide out there for you so that you understand, for those of you who are not necessarily super involved in this, that there are different panels of drug tests, and there are also different ways to test for drugs and alcohol. You can test for marijuana or not. Like Elizabeth and I have talked to a couple of clients this year, and they've decided they're just not going to test for it. Cocaine, believe it or not, is becoming sort of cool again, and we're running into that more and more. The Ohio BWC is not paying for marijuana. They don't care how many times it's going to be recommended. And we specifically use the word recommended today because marijuana cannot be prescribed by a doctor. Why is that? Because it's a Schedule I narcotic drug, illegal as far as the federal government is concerned. So it cannot be prescribed. Therefore, it can't be paid for by the Bureau. It's not a formal drug, I guess would be the way to put it. So sort of in summary, a drug testing policy is really something that an employer should come up with after discussion with all parties involved. That includes employees.
Yeah, so what makes sense in your workplace? Address just in summary the purpose of this policy, right, to keep employees safe, and then the scope, what are decide what you're testing for, how you're testing for it. Are you including marijuana? Are you excluding it? Are you doing reasonable suspicion? Are you doing post-accident? What is the scope? And then, certain things can talk about maybe assistance. So
employee assistance program.
That's sometimes it's employees who have a drug problem that they have some freedom to come to their employer and say, I need help, and you'll get them that help. But also, what are the work rules looking like? So, like Carl said and read that sentence a minute ago, that's a perfect work rule that if someone leaves the scene of an accident failing to do a drug screening, that it's going to come back with a failed result. And then, continue testing and then the consequences, and we already touched on the confidentiality.
So let somebody know if they test positive, they can be terminated, or they can, some employers, I think we've written a policy like this recently, they have the option to go through rehabilitation and participate in the employee assistance program, and then come back to make sure that for a year or so they don't violate any policy.
Yeah, and again, that's an option. You can't ever force an employee to go to rehab. So I think we get that question a lot that, well, an employee tested positive for this drug. We want to force them to go to, AA or NA or something like that. And you can't force an employee, but certainly you can be a partner with an employee to help them get the help they need.
Reminds me of a lawyer joke. You bring a client in and the person shot somebody, and you tell the client, hey, look, Murphy, just because you did it doesn't mean you're guilty. So just because somebody has a drug and alcohol problem doesn't mean that, they're a worthless piece of crap and you fire them. Maybe you make the effort to give them the option to get beyond the situation. This last slide really is just to let you know that medical marijuana is discussed in detail in the Ohio Workers' Compensation Law, specifically Revised Code 412354. If you have any questions on that and you like to be bored to death and you can't sleep at night, you can actually read that section of the law, or you can contact us and we'll explain it.
Yeah, but in essence, all it says is that if an employee does test positive for drugs or alcohol, then when there's the workers' compensation claim, employers like us have a defense to get the claim, disallowed, or maybe it's a certain condition or what the case may be. But it just provides a defense. And one way of doing that is having a drug testing policy in your handbook.
Exactly. Wow. Well, are we about done? Is this about... Oh, we've got a few minutes here. This slide just tells you what all we've talked about. In 55 minutes, we've talked about workplace violence, temporary employees and the importance of training them, distracted driving, other safety issues, how important it is to have a very clear reporting policy for injuries and how you don't want to retaliate against people who do it, and then drug and alcohol testing policies. Carrie, do we have any questions?
We do. So someone has an employee who had an injury and they went to the doctor exactly 2 years to the day that she says the injury occurred. Now she needs surgery and she never told the employer until now. No report. What can we do?
Well, that's a statutory issue. The old law, well, first I'm going to address what appears to be the obvious question, and that's whether or not it's a workers' comp injury. In the old law, employees had 2 years to report an injury and file a claim. In fact, they didn't even have to report it within 2 years. They had to get the claim filed.
Yep, they have to give notice to the Bureau or Industrial Commission. So
yeah, there is a savings clause in there that gives them an additional 6 months if they notified the employer and nothing was done about it. But that law's changed, and it's now 1 year of the statute. So first, the question to me poses a legal argument that the claim is barred by the statute of limitations. So it's probably not a workers' comp claim. The other question, now she needs surgery. She never told us until now. What do you do?
Yeah, so you would probably, depending on where this would go, you would want to get medical documentation showing that it wasn't related to the accident or the injury that did occur 2 years ago. So there's a couple ways you can go about it. One is the preliminary, which is disputing it and saying that, it just didn't happen. And then two is with the legal analysis that it's barred by the statute of limitations.
Sure. Well, and let's also now that's a great question, by the way. Let's bring it back to what we just talked about. You have policies in your handbook that says you have to report an injury as soon as practical, or as soon as possible. And 2 years later, definitely is not as soon as possible. What do you do in a case like that, Elizabeth? Would you recommend that if this person is still employed with you, that you reference the handbook and say, we're gonna follow our disciplinary policy, maybe a written warning or something?
I mean, to be honest, if we were on a telephone call and that would have been your question, my first question back would be like, let me see your policy. What does your policy say? But because we are on the webinar, I didn't want to respond that way. But yeah, certainly, I think you definitely have an argument, at least a response back to your employee that says, unfortunately, you didn't follow our policies. So, our hands are kind of out of it at this point.
And it's important, I keep going back to this. It's important for your other employees, for the safety of all of your employees, that as the employer, whether somebody got hurt or not in a timely fashion. 2 years later, and this person needs surgery, it must have been some significant safety hazard that ended up causing that, and this person didn't care enough about their coworkers to even let you know that you have a safety problem. So you can approach this issue multiple ways. If they have any other questions, they can give us a call.
All right, the next question is, any references for language to creating the workplace violence policy?
I mean, there's a lot of different ways you can go about it, and I think the language is going to depend on, one, how the rest of your handbook reads. So you're going to follow that kind of language, and then two, what makes sense to your culture. So like Carl referenced earlier, if you're a bank, your workplace violence policy should probably read more in the eye of, maybe a possible robbery or,
right,
something like that. But
a criminal.
Yeah, a criminal. But if you're really in, kind of an office setting, maybe it reads a different way. And so there's no right or wrong answer. And unfortunately, to be the bearer of bad news, the total lawyer phrase that it depends.
Well, I think one thing we can agree on for sure is that every policy should say we have zero tolerance for workplace violence. And then you got to define workplace violence.
Right.
Yeah.
And then obviously, how to report it, how to stop it, who to contact.
Right.
And then that there will be no retaliation for people who report. So that's a pretty good framework. Yeah.
And then the last question we have is, under your distracted driving policy, does engaging in a phone conversation include speaking on the Bluetooth?
Yeah, so that definitely does. I think it includes both handheld devices and Bluetooth devices. So just because someone's not holding a phone in their hand, they're still not paying attention to the road in front of them. They're thinking, they're concentrating. Maybe they're, telling Siri to take some notes. But it certainly extends to both.
Yeah, and that's an arguable point. I would agree with you that that's the best recommendation. Some states, however, on their law, they don't make it illegal to talk on a Bluetooth hands-free. But what you were saying and I was saying is that whether it's hands-free or handheld, you're distracted from focusing on driving.
Right, and so it doesn't matter if someone's holding a phone or not. If they get in an accident or something and they're working, that's where your liability is.
Exactly.
So it doesn't really matter the means of how they're doing it. It's the fact that they're engaging in that behavior.
Yeah. Let's face it, if you're in sales, and you're driving all the time, it's going to be hard not to be talking on the phone, hands-free. Elizabeth is smiling because she knows someone very close to her who does in sales and travels quite a bit. So, well, I don't see any other questions, Carrie. Is that it? Well, we'd like to thank you very much for spending the last 60 minutes with us. We hope you enjoyed it. We hope you learned what you needed to learn. We will have 2 more Employment Handbook webinars this year. It's on our website, isn't it?
Next one's on June 19th.
Okay.
And that is addressing leave.
Leaves? Yes, I think it is. And so you have our contact information. Please contact us with any further questions. And nothing further said, we're going to close it. Thank you.